That means
there
it is defective.
defects. So you cure the defects.
It must be
automatically it will
defective.
appear.
You give the number and intimate your other side.
And you verify also the report, stamp report.
All the list.
Lordship and Ladyship, Advocate Jagriti Mishra is in court number 6 on his legs, and he will be appearing for the matters here from item number 1 to 6. Kindly keep a short passover.
For item number 1, paying for only 1 day. Tomorrow.
Not today.
Not. Lordship. And for the other matters till item 6, ma'am.
Just wait. Let us see whether the other side
All right.
is there or not.
Not today.
Item 1 not today.
Not today.
Passover.
Can you start?
Ashwin, the other day I had started this thing
Yes.
and the report was called for whether the regarding the paper book.
The TCR was received on 17/7/2025 found defective. Text of removal of the defects. On June 25 till July 26. It is
Yes.
Other side is ready.
Yeah, Mr. Mishra.
Yes, ma'am.
You
We
are
are ready
already
with it.
sweating in the morning. It's
No, no.
just 10:35.
It's a luxury to come at 10:30. I availed that today.
5 minutes late.
So you may start.
Lordship, I have already started now.
Just
Lordship, I
recapitulate,
Just
recapitulate the facts.
With so many
Actu-
matters.
Actually, Lordship, I don't want to be blamed for the second time from obstructing the government.
Proceeding has been initiated. Writ was preferred. In the writ, during the hearing of the writ petition, a report has been submitted wherein they admits that some portion has been utilized, but the remaining has not been admitted, my lord. Accordingly, the writ was disposed of, directing to initiate appropriate proceeding for payment of compensation, my lord, in accordance with law, my lord. My lord, if you should kindly seize the report, my lord. I've made a comparison at page 113, my lord. This is my exception to the report. The map shows, my
What
lord.
is CAN 1?
My CAN 1 is for delay has been disposed of, my lord. My lord, these are the plots that have been utilized, my lord. My lord, the first column is the plot number, my lord, page 113.
Let us go through the order in two order.
My lord.
Improved order.
Yes, the impugned order.
That is with the
Wait,
memo of appeal.
Lord, the writ application has been preferred, praying for direction upon the respondent authorities to initiate appropriate land acquisition proceeding in terms of relevant provisions of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013. On hearing the learned counsels for the parties, it appears that the petitioner claims that the road which has been constructed by the respondent state authorities has been done by using 1.95 acres of land of the petitioner herein, and as such, the petitioner is entitled to compensation for the taking over of land measuring 0.72 acres and not 1.95 acres, as claimed by the state. On hearing the parties and on perusal of the materials on record, it appears that the state has filed its report and the petitioner has filed exception thereto. The report submitted by the state shows that a total area of 0.72 acres has been used by the state to build a bridge for public use, and a Pakka road has been constructed in place of Kacha road, which was also being used by the public. It is further stated that no further construction nor any nature and character of the property has been undertaken by the state other than by way of development of the area. A map submitted by the state authority shows that the road has been constructed adjacent to plots numbers 388, 389, 391, and 398. The petitioners claims that certain portions of the land in plots number 414, 415, 417, and 418 has also been used by the respondent state, and as such, the petitioner herein is severely prejudiced, as the petitioner is entitled to compensation for 1.95 acres of land. On perusal of materials on record and the map annexed to the report by the state, this court finds that the state has not used any portion of the land in respect of plot number 414, 415, 417, and 418. As such, the petitioner's said claim has no merit, and the respondent state authorities are directed to proceed to grant compensation to the petitioner in accordance with law to the extent of portion of land used by the state for making a Pakka road in place of Kacha road used by the public is in respect of the 0.72 acres of assessed. Writ petition application stands disposed of, Malad.
What is
Malad,
your case?
My case is that, Malad,
1.95 acre of land was
utilized, Malad. Malad, apart from construction of bridge and road, Malad, there were barriers also have been constructed to protect the bridge.
How Writ court can decide this issue?
Malad, if a re-inspection is directed, Malad, that can be assessed, Malad. The report is not fully conclusive, Malad. If you also kindly sees the report 102, Malad. Nowhere it talks about the barriers, Malad.
And even barrier is constructed, which plot of land?
Yes.
Whose land is that?
My land, that.
Decide. Writ court can decide.
Well, since
that issue.
Well, I'm only praying for an inspection, my lord. Let that be conducted, my lord.
Can a roving inquiry be done?
My lord.
Can a roving inquiry be done?
Well, since Writ court has relied upon a report, my lord, which is not conclusive, my lord.
Who knows? The state is filing a report. Why will the court take it as to be inconclusive?
My lord, since other plots have not been, have also been acquired,
These are
utilized,
disputed
my lord.
questions of facts. The writ court cannot decide at all. Has compensation been given for the 0.95?
No.
Only
There
admitted
tea
by them,
bushes.
that can be directed by the Writ court to pay the compensation, otherwise.
In
we
respect
have
of
to-
0.72.
72.
Are you
Another-
taking steps? Is the state taking steps to pay
Oh, if they came
compensation?
in appeal, we will take steps, we will pay them the compensation.
My lord, the land was utilized in the year 2021, my lord.
You can
Still-
receive
till
the compensation without prejudice, and rest of the land you may.
Well,
take
kindly grant me
recourse.
liberty to take
There
appropriate
is a
steps.
vociferous averment on part of the one party. Let's forget state and petitioner here. And there is an equal and flat denial on the part of the other party. Then it becomes a disputed question of fact.
That's why we are saying, at least admitted a compensation may
yes,
be
yes,
accepted without prejudice.
And for the
Moreover,
rest, in accordance
Moreover,
with
the
law,
Writ
they
court
will
has not appreciated that there were tea bushes also.
Yes,
That has
what
not
for the writ court to
compensation,
appreciate?
land
No.
includes everything opportunity to the land.
Then Malad kindly grants me liberty to
This
Yes,
liberty is
they
also
all-
not
Malad kindly
required.
adds that, Malad.
Unless
Since
they
I've approached the Writ court,
Yes, you can approach before.
Malad,
the
unless there is a
appropriate
liberty,
forum
Malad, I
for
cannot
rest of the
challenge
land.
the
Malad,
order
unless there
dated
is liberty, I cannot
25th February 2026,
since I've approached the Writ court,
passed
Malad.
by the learned single judge.
Hmm? Hmm.
Stop. By the said order, the learned trial judge was pleased to observe that the petitioners do not have any, that the petitioner's claim for compensation does not have any merit. And the state respondents merit in respect of 1.95 acres of land. And the state respondents were directed to proceed to grant compensation to the petitioner in accordance with law to the extent of the portion used by the state for making Pakka Road in respect of 0.72 acres of land. Paragraph. The specific claim of the petitioners is that 1.95 acres of land have been utilized by the state. Stop. The court merely directed for payment of compensation in respect of 0.72 acres on the basis of the report submitted by the state respondents. Stop. Prayer has been made to direct the respondents to pay compensation in respect of 1.95 acres of land. Upon hearing the submission made on behalf of both the parties and on perusal of the materials on record, it appears that the petitioner's claim regarding acquisition, regarding utilization of 1.95 acres of land has been plainly denied by the state authority. Step. The state has admitted utilizing 0.72 acres. Step. Once the state respondents denies the claim of the petitioner, the issue becomes, now the factual issue becomes disputed. Step. Such dispute cannot be resolved by the writ court. Stop. Next. In view of the above, the court is not inclined to interfere with the order passed by the learned single judge. Stop. It will be open for the petitioner to avail remedy in accordance with law for seeking compensation in respect of the balance portion of land over which
Grateful.
the petitioners claim right. Right, claim right.
With regard to the compensation of 0.72, is.
With regard to the compensation of the admitted
Disposed.
portion, if that may be expedited, my lord.
What thing?
With regard to the admitted portion, claim of compensation, that may be expedited.
The, on the,
So far as the compensation is.
as
concerned,
regards the direction passed by the learned single judge for grant of compensation to the petitioner, the state respondent shall take steps to grant compensation expeditiously.
My lordship.
Grateful.
All disposed. Can also.
My lords, I appear for the appellates. May I place my case, my lords?
Yes, certainly.
My lords, this intra-court appeal arises from the order passed on 28th April 2026. It was a ex parte order, my lords. There was an election week. There were resolution passed by the bar not to appear, no adverse orders, and we were under the bona fide impression that orders will not be passed. But nonetheless, my lords, I was relegated to the G-Stat tribunal. Now, my lords,
Who is
my
the other
argument.
side? You are.
Now, before getting into the arguments, I will just place the facts in a very short compass, my lords.
We
Now,
will not go into the facts since it is an ex
Already
parte order
relegated.
yes,
and it has merely been relegated. It has not been decided on merits.
but I am on the relegation aspect only. I am on the relegation part.
Yes.
I will not take much time. I will not waste the time of the court, my lords. Facts, I will just hardly take a minute. I am a person, I execute works of NHPC. There was a mismatch between the returns filed by the NHPC and my returns. As a reason, department flagged this mismatch and an ex parte adjudication order was passed. I could not participate in the adjudication proceedings also because my own brother, who was the main person in charge of the accounts of the company, he faced a terrible accident. It was almost a fatal accident, skull injuries, everything I had supplied. After that, I came to know of the order on belatedly on through the recovery proceedings. And after that, I filed the appeal. My appeal was delayed. It was 47 days delay, merely 47 days delay. And it was dismissed on the grounds that delay cannot be condoned. Now, the only issue, I came before the writ bench, I was relegated. Now, my lords, my facts, my submissions are on two limbs. Firstly, with respect to efficacious alternative remedy, which my learned senior has been insisting on, that since the GSTAT has been formed, you should go there. On that aspect, first part, this is an office order, my lords, which is passed by there. It is available in public. This is last month's order. Here they have created benches of all the GSTAT benches have been constituted by way of this office order, my lords. If my lords will see page 12 of the page, it says Kolkata, and two benches have been allocated, both with technical member of center. If my lords will see Kolkata 1 and 2, there are technical members from center. Now, if my lords will see the Act, section 1094, it says that the composition has to be one from, there has to be members. If my lords, I'll just place one section.
But you are not challenging this.
No, what I'm saying is today there is no technical members which has been appointed by the state of West Bengal as of now. And that is the reason there are no SGST matters which is being heard by the tribunal. And this is not an efficacious remedy, my lords. The only registry is open. If my learned senior can give a statement, because this issue was also raised before Justice Chanda, and my learned senior had placed before the court that he will take instructions on this matter
Let him take
and come back. Because and this is on first aspect, on efficacious remedy. On the second
So
aspect,
you
my
are
lords,
saying the tribunal is not functioning.
it is not, it is functioning, it is administration is open, the registry is open, CGST matters are being heard. This matter arises out of SGST because there is no technical member from the state of West Bengal. That is the reason.
That he will take instruction.
Yes. And on the second aspect of my submission, my lords, even assuming, arguendo, that there is an alternate remedy and tribunal is functioning, even then, my lords, I have been suffering from the forum, from the adjudication, my lords. It is an ex parte order, appeal dismissed on limitation, ex parte single judge's order, my lords. And my lords, this issue, the only issue which arises here is whether that delay is condonable or not. That question has been answered by this court, my lords. And again, if I will be remanded back, my lords, it's give a wrong signal, my lords. What is the use of them?
The second argument, my lord, that
deciding-
is a question of law. We will argue and finish it off today.
Why? What is the use, my lords, when the
Chief
assessees
Justice's
are
order
coming
is there,
here?
isn't it?
My lordship,
Justice Shivangan's order is there?
Yes, my lord, I will place. There are two division bench orders, my lords,
Yes.
where clearly it
has
has
been
stated that
condoned.
delay can be condoned because there is no
But then
exclusion.
this order can be placed
Milords,
over there. It
in the
can be
tribunal
done.
as well.
Kindly
That can be done.
appreciate, my lords.
But only thing is,
My
we want to
lords will
know whether
appreciate
it is
one aspect.
functional or not.
Yes,
Just
as far as
one
the first
aspect.
aspect of his argument is concerned, that is something that needs to be looked into. The second one can be,
also.
no, the second can be disposed of today itself.
Then
Yes,
if that can be disposed of, then he is.
Then he will,
I
he will go to a tribunal. The first one will not be heard.
no, yes, absolutely. That is my case. And my lords, I am placing reliance on a coordinate bench decision. Absolutely similar facts. Division bench order relegated to the adjudication authority.
After
Relying on
condoning-
our division
after
bench.
Condoning the delay.
Yes, because they have the power, my lords. It is 47 days delay. And
Then-
I
then
have
in that
paid, my
case-
lords, before preferring appeal, I have paid pre-deposit as well. My bona fides is there. That they cannot dispute. I am only asking, my lords,
Because,
let
my lord,
them
the-
decide my case on merits.
Because the second leg of the argument that he's placing is a question of law.
Yes.
Let's have for a moment on the second question, the second limb of the argument that he's saying. And then if at all it is felt necessary, he can be relegated to the tribunal. If I can have my lordship for a moment on couple of judgments. ले दे।
You've brought the whole thing.
Yes,
Chabil
yes,
Das
yes.
Agarwal. Oh, yeah, what a
We will
company.
begin with Chabil Das Agarwal. Now, Chabil Das Agarwal, my lords, was a judgment that was delivered in 2013. When there was no concept of GST, when there was no concept of GST tribunal, nothing.
Sorry, if
Plain and
just
simple.
one thing, sir. I will also place reliance on one decision. After that, my senior can start. This is one decision I'm relying. Another decision on the alternate remedy point. I don't want to give judgments from Whirlpool and all. Gautam Bhumik, paragraph number 13. And I'm squarely covered. In this case, this is a GST case. And after analyzing several judgments from the Supreme Court, this court, coordinate bench, has given out a list of cases where, in spite of having alternate remedy, what are the categories of cases where people can come? That is para 13 of the. So I'm also relying on this because I'm squarely covered, my lords, at point number 10, point number 3.
Which one?
Para 13, my lords, Gautam Bhumik.
Gautam Bhumik. Paragraph 10.
Yes, my lord. Paragraph 13, my lords. 13.
Yes.
These are the exceptions. It has given out the elaborate list. I fall, my lords, on 10, on 3 and 10. My category absolutely fits there. That is my short submission. After that, there are a lot of judgments which has been cited. I don't want to trouble with that. Chabil Das Agarwal and everything is there, considered. Then my senior can start. That is what my submission.
Well, this is a highly contentious issue. This is something, I mean, there is nothing better argued before this court than what would happen in cases where an equal efficacy remedy is available. There are two kinds of statutes. One, my lords, happens to be a general statute, and on the other hand, there are special statutes. All fiscal statutes, by the very nature that it is fiscal in nature, they are all special statutes. They are complete code in itself. So what will happen is the adjudicating authority, the powers of the adjudicating authority, everything will be provided in the statute itself. The first appellate authority, the powers of the first appellate authority, when the first appellate authority can interfere, when it cannot interfere, by way of appeal, by way of provision, provided in the statute itself. The second appellate authority, when the second appellate authority will interfere, the question of appeal and revision, everything is provided in the statute itself. Thereafter comes the tribunal. So there is an adjudicating authority, there is a first statutory appellate authority, and after that 107 is the tribunal. Then after the tribunal, if somebody is not satisfied, then what will happen? Then it will again come back to the writ court. Before a division bench, it will be marked as WPGST. I will come to the scheme of the act. Before we go into that, even before the GST Act was not implemented, or even before we didn't knew as to there would be a concept of a one nation or one tax, what was the opinion of the Supreme Court with regard to fiscal statute is somewhat clear in the judgment of Chabil Das Agarwal. If I can have my lordship on the booklet that I have given to my lordship. Chabil Das Agarwal matter happens to be a case wherein an income tax assessment was challenged. Now, prima facie, from the very look of it, the assessment was bad. Why it was bad? This was assessment for the year 95-96, and it was issued to the assessee in the year 2001. So it was barred by statute at that point of time. The court would have simply said that this is an assertion of power that is happening. The authorities are acting beyond jurisdiction. The authorities shouldn't have done that. What the court holds is important. It starts with paragraph 8, my lordship. Second page of Chabil Das Agarwal. And then from there, we will slowly travel to as to what is the opinion of the different high courts that are there in and around our West Bengal. So we will go to Odisha, we will go to Guwahati, we will see what the Sikkim High Court has to say, what the Patna High Court has on this very aspect.
Do you think all this is required?
The tribunal is there, they have to go to the tribunal.
See, it's only condonation of delay.
Yes.
If the delay is condoned, you take steps. It was an ex parte order.
Yes, my lord.
Yes, that is true. It was an ex parte order. But at the same time, what has been held in the ex parte order, the limitation, they can get a condonation of the limitation that is there, and they have to go to the tribunal.
Why? If there are cases where the delay has been condoned earlier.
No, that's true. But
And-
those are cases, my lords, in my
When the
respectful
tribunal
submission,
was not
when the
functional.
tribunal was not there.
Right.
In fact, these writ petitions, they are admitted because the tribunal is not there.
True, true. But if this is the submission that the tribunal is not functioning and it's only
That
the
comes to the
registry,
first leg of the argument. Yes,
the registry
yes.
is functional and it is only for remanding it for dealing with a settled point, then I think you will be delayed. Because if it is at all allowed by the tribunal, then again also it goes back to square one. If the delay is condoned, it goes back to
Only here
square
is the-
one,
It does.
isn't it?
It does.
This
So
is-
if we send him to square one at this
Yes,
stage
madam.
only,
And let them thrash me out on merits. I will pay the taxes.
no, that is different.
That is a different
That
thing.
is absolutely different. Whether we can send it back from here only.
But my lordship, wouldn't that amount to utilizing the writ court as a court of extension of limitation then?
No, no. It was at one point of time because of non-functioning of the tribunal, but then settled law.
My lordship,
And
Absolutely.
one more thing, my lord.
we will do that.
There may be cases where you
I
can't
understand
do
that.
all these
I
things, but
understand that. Yes.
particularly in
Yes.
this case, even the writ court,
Didn't go
all
into the
didn't
merit
go
of the
in.
case. It has simply relegated him there.
absolutely nowhere his case was decided on merits.
That's true.
From the very inception of the case, it was ex parte, ex parte, ex parte.
There was a reason behind that.
Deliberately chose not to.
They filed the writ petition. Then the weather was not good. Black clouds were there. Thunderstorms were there. My lordship, Honorable Justice Kapoor has to come. So the case was not placed there. Now the weather is fine. So now the case is being
The
closed.
weather was not fine till yesterday, I think.
I don't know. So that is all there.
So what to do?
Whatever my lord says.
Amen, correct.
So yeah, thank you.
See, as it is an ex parte order, we could have sent it back to the trial court also, but we are not doing so. It's
Yeah, I
sending
understand
it
that.
back
I understand.
so that at
In the
least-
normal course, it could have gone to the writ court itself. Because,
Absolutely.
yes, I understand.
But since
But again, the weather would be nice
You
or
never
not,
know.
that is something that also needs to be looked
Questionable.
into. It's very stormy
Questionable.
these days.
questionable whether
Questionable weather.
the petition challenges the order dated 28th April 2026, passed by the learned single judge by directing the petitioner to avail the statutory alternative remedy before the G-stat in accordance with law and after complying with all necessary formalities. Stop. Paragraph. The aforesaid order was passed in the absence of the learned advocate representing the petitioner. Stop. It has been submitted by the learned advocate representing the petitioner that on the day the matter was disposed of, there was a resolution adopted by the Bar Association for not attending the court proceeding. And a request was made before the Honorable Court not to pass any ex parte order adverse to the parties. Stop paragraph. It has been submitted that in view of the resolution adopted by the Bar Association, the learned advocate for the petitioner restrained himself from appearing before the court. Stop. Due to non-placing of the case on merits, the learned single judge decided the issue relying upon the submission made by the learned counsel for the state. Stop. prayer has been made to set aside the said order and to hear the matter on merits. Stop paragraph. It appears that the petitioner is aggrieved by the order dated 18th December 2025, passed by the Deputy Commissioner of Revenue, Darjeeling, under Section 107 of the West Bengal Goods and Service Tax Act, 2017. Stuff. The order is an appealable one. Stuff. As the petitioner approached the appellate forum at a delayed point of time, the appeal preferred stood rejected. Stuff. Learned advocate for the petitioner submits that there are sufficient grounds for condonation of the delay in filing the appeal. Stuff. In support of such submission, that the delay ought to have been condoned by the authority, learned advocate for the appellant relies upon the judgment delivered by the Honorable Division Bench of this court in Ashok Ghosh versus State of West Bengal and others, reported in 2025 SCC Online Cal 8646. Wherein the Honorable Court was pleased to direct the appellate authority to reconsider the prayer of the appellant for condonation of delay after giving the parties opportunity to bring materials on record in support of their respective cases. Stop. Paragraph reliance has also been placed on the judgment delivered by the Honorable Division Bench of this court in the matter of Gautam Bhomik versus State of West Bengal, reported in 2024 158 taxman.com 399 within bracket Calcutta. Wherein the court reiterated the principles which lay down the exceptions to the rule of alternative remedy as settled by the Honorable Supreme Court. It has been reiterated that when an order is prejudicial to the writ petitioner and has been passed in total violation of the principles of natural justice, and where a decision or policy decision has already been taken and where there is a factual dispute, but where a decision or policy decision taken in. Natural justice बोलना तो.
You have said 10, serial number
Yes,
10.
yes. No factual dispute, only pure question of
And
law.
when and where there is no factual dispute, but merely a pure question of law or interpretation is involved, the rigidity of not entertaining the writ petition ought not to be relied upon. Stop. Next. The court also held that the availability of an alternative remedy on the facts of the case would be. No, I take it again. I take it again. Court also held that paragraph. In the instant case, it appears that from the very inception of the adjudication proceeding, comma, the petitioner, for reasons best known, could not avail the opportunity to approach before the authority to defend its case. Stuck. All along the proceeding was held ex parte. Stuck. Whether the petitioner had genuine reasons for avoiding the forum ought to be looked into by the appellate forum for proper adjudication of the list. Stop. Paragraph. Admittedly, in the instant case, the stage of any factual dispute has not arisen till date. Stop. It is only regarding the condonation of delay that the court is entering into the matter. Stop. The paragraph in the facts and circumstances of this case, comma, the court is minded to relegate the petitioner, appellant, before the appellate forum for adjudication of the case on merits. Stop. The appellant is, it will be open for the appellants to file a proper application seeking condonation of delay, which the appellate authority shall consider in accordance with law. Stop. If sufficient cause is shown, comma, then the appellate authority may condone the delay of the appellant in approaching the statutory appellate forum liberally. We make it abundantly clear that we have not entered into the merits of the matter, and all points are left open to be decided by the appellate authority on merits. Stop. The appellant shall approach the appellate authority positively within a fortnight, fortnight from date. The appeal of the connected.
Just one
application
indulgence,
stands-
my lords. My lords have said that the
28th of April 2026 stands set aside.
just one thing, my lords have said that I will file an application of condonation and they will decide again. Lords, this
Liberally.
again comes round two, it will happen, my lords.
Maybe, but we
At
cannot
least-
decide.
Because I
till
had
we
filed an
decide.
You
application.
show at least you had genuine reasons.
No, I had shown that. They
That
said
That
we
they
are
will
not
do.
going. into
very
the
well.
merits.
I'm grateful. I'm grateful.
Deeply obliged.
Take back your spiral. You'll
My lord.
require it in other matters. Otherwise, you go on printing spirals. Acha. This also take back. Please return this to the learned advocate for the appellant. These office orders and everything is not required.
नहीं
9 তো 2 তারিখ করা আছে। 8
Impugn order. For the Union of India, Lordship. I am appearing for the Union of India.
So this appeal Millard is against an order dated 16th February 2026. And in the writ petition Millard, the subject matter of challenge
was Millard a notice of audit issued under the GST Act. Millard, I won't go into the provision right now, Millard. The provision of law is, Millard, that the notice has to be issued within 15 days. Subsequent to the audit, if
Act টা দেখি একটু। Give the act in
GST
GST Act.
তোমার বইটা নাম
তোমাকে দেবো?
ওই যে সামনে আছে
না,
কোম্পানি
ওখানে আছি।
এই যে সামনে জিএসটি।
Yes.
So the relevant provision is section 65.
Yes.
Subclause 1, the commissioner or any other officer authorized by him by way of a general or a specific order may undertake audit of any registered person for such period at such frequency and in such manner as may be prescribed. The officers referred to in subsection 1 may conduct audit at the place of business of the registered person or their office. 3, the registered person shall be informed by way of a notice not less than 15 working days prior to the conduct of audit in such manner as may be prescribed. The audit under subsection 1 shall be completed within a period of 3 months from the date of commencement of the audit, provided that where the commissioner is satisfied that audit in respect of such registered person cannot be completed within 3 months, he may, for the reasons to be recorded in writing, extend the period by a
Why
further
go to all
period.
this? Just
Yes,
right now it is-
not required.
Ah,
Now immediately thereafter, Millard kindly takes 73 and 74 ones,
ah.
73 and 74 sections.
Why go to 73?
Millard,
73 stage has not
No,
arisen.
no, Millard,
No.
the entire case is based on that.
No. Where is the bar in
Millard-
issuing the notice under section 65?
Millard, 65 notice, there is no bar.
Then
Our challenge is, Millard, due to the
why the
reason,
notice was issued for
the
the year
notice, Millard, the
2020?
notice discloses a predetermined notion.
No.
That is, Millard,
No,
that is,
sorry,
Millard, the
sorry,
simple case. Millard, kindly have a look at the notice
Whether
once.
15 days prior notice was given or not.
No, Millard, see, they are intending
That
to
is
proceed
not the
under
issue.
section 74.
That is not
Intending
the
to
issue.
proceed under section 74, Millard, that is the entire, Millard, reason why we have prepared this
That is
petition.
still-
The
is not
court
come.
see specifically mentioned that
Page
this is
42 of the writ petition.
premature.
Millard, page 42,
Page 42
page 42
of the supplementary affidavit?
of the supplementary affidavit, wherein, Millard, the writ petition is annexed.
Yes.
And this is, Millard, the 4th notice.
Right.
There were 3 earlier notices
So
issued.
you are
Which-
deliberately
No,
withholding,
Millard, not
standing in
deliberately.
the way of conducting
Yes.
the audit.
No, Millard, kindly do not make that notion, Millard, at this
Why?
stage. Millard, let me place my case first.
You
Millard,
have placed
at least 5 minutes, Millard.
Ah,
Millard, prior to page 42, which is 6 January 2026,
Hmm.
Millard kindly comes over to page 29, which was the first notice. 5th May 2025, page 29. They are intending, Millard, the first line of the notice, undertake audit of your books of accounts and records for the financial year 2018-19 to 2023-24. Now, Millard, immediately thereafter, Millard, kindly turns over, Millard, at page 31, wherein we intimate them that you cannot undertake audit for all these financial
Yes.
years because you are,
How? Why
because,
are
because
you
this is
saying
time
this?
bar. This is
Where
time
is
bar.
the time bar? Section 65 does not prescribe a time limit within which an audit
Now,
notice
Millard,
is to be
kindly
given.
seize their reply. Seize their reply, Millard would
We will not
understand,
go to
Millard.
the reply.
Millard, it is absolutely a targeted exercise. Why I say this? Millard, kindly then turns over to the Millard the next notice, which is at page 32, 19/11/2025. After receiving our reply, they again issue a notice which does not provide for the 15 days timeline. Very well. Against this notice, Millard, we make a representation. Against that representation, they give us a detailed reply. Page 34.
Yes.
Page 34, Millard, kindly sees para 5 onwards, which will, Millard, clearly indicate what their intention was. In the point number 4 of your letter dated so-and-so, you have mentioned that as per provision of section 73 of the CGST Act, financial year
See,
so-and-so.
suppose if any decision is taken in respect of a time barred claim, you can always come to court. Who is stopping you?
Yes.
No,
But why will you not permit them to conduct the audit?
my only concern today, let them conduct the audit. There is no
Yes.
difficulty. But it should not be with a predetermined mind that I am proceeding under
How-
section
how?
74.
How can you say
Yes.
this now?
That from their reply, even,
Challenge it at a later stage.
even Millard at page 42,
Challenge it at a later stage.
Millard, even
It
at
is
page
open for you.
42,
Please
Millard
stop.
at
No,
page
nothing,
42,
nothing.
Millard kindly sees is only barred under section 73 and not under section 74. What does this mean?
You are not
If
challenging that.
you are quoting this,
An order is passed
Millard, if
in
Yes.
respect of a time barred claim, the court is open
Millard,
to you.
if they themselves say that yes, it is not barred under 73, but under 74 it is allowed. It means, Millard, they are moving with a predetermined motive to Millard initiate proceedings under section 74.
Dated 16th February 2026.
Millard kindly clarifies that they should not proceed with a
how
predetermined
we
manner.
can
that it is
Lordship,
under
clarify
section
if
74.
we have
What
not
is the
initiated,
motive?
yes,
How can we
it's
say
a
this?
pre-imagination because we have not initiated the audit.
Nothing.
The findings is not there
Had there not
How
been a
they can come?
determination, Millard, this should not have been
Because-
quoted.
because 65 7 is already there. Protection is there to the petitioner.
Disposing of the writ petition by holding the same to be premature is impugned herein. Now, is challenged by in this appeal stuff paragraph. It appears that the petitioner challenged
GN
the
number 10 was the
notice of conducting audit.
Millard, I have
Dated-
just, Millard, one more point to add, Millard. I'm sorry for the interjection, Millard. Millard, by way of a notification, which is there in the supplementary affidavit, Millard, it is mandatory to quote a computer-generated DIN number in the notice. And all of those notices miss the DIN number. Let them comply with that and issue a fresh notice. So that
Lord-
it is there in the centralized portal. Someone gets to know that yes, an audit is condemned.
Lordship, that is also the wrong submission because the first audit has, notice has got the edit.
The first notice has been
Yes,
subsumed.
sir,
It has
you-
become defunct. It
Af-
is only the notice
after that
dated
also,
6
Whether
January
in
which
the
stands
last
today.
notice you have
After-
mentioned
after-
that.
No, they have not. They have
In
not.
the last notice.
Millard, the circular is at page
Lord-
This is
49.
in continuation of the first notice.
It cannot be, Millard. It
Lordship,
cannot be a
there is
continuation.
Subsequent circular.
Yeah.
They are suppressing the thing.
What does it
Because
say?
it says only the issue number has to be there. And issue number is there in the second notice.
Issue number.
Yes, that can be verifiable.
Millard, the second
I
notice
will-
has subsumed now. It
No,
has
no,
nothing
no,
to do.
kindly-
It has lost its force.
Because
Where
if
is
you
the
are,
second notice?
if he
Page
is, a-
32. Page
Yes.
32.
yes, I am just.
Issue number. Which one is the issue number?
I number at the top, Lordship. It is 32, Lordship.
Page 32.
Circular একটা copy.
Because if they are disputing at this,
Show me the I
yes,
number.
yes, yes. At the top, right hand side, I 36614222025.
Page 32.
Right. Annexure P3 just below.
Oh, acha, I number.
And it can be verified.
Both are right
It is, but Lordship, I will just take to the,
এখানে কোথায় বলা
because
আছে?
Lordship, Dean, there is some problem and complications. So now there is a E office. So E is out because there is the multiple things. So now the government has devised a system. You go to the E office, and you put your digital signature, name of the petitioner, email number, and you generate you send the notice. So automatically, issue number will be there on the top.
Very
So
well.
I'm
This circular comes into force on 23rd September. And
Yes.
they have issued it on
yes, after that.
19th of November.
Yes.
November পরে। But
Yes.
this is not the notice on the basis of which they're conducting the audit. Subsequent audit
Does
notice.
the I number remain same all through?
No.
No, every,
Not at all.
Every time it
yes,
changes.
Every time changes,
Right.
Millard.
So will you
So-
give fresh notice?
Yes, so if Lordship directs, because you see, Lordship, they are just not allowing the audit, conduct the audit. So only prayer is to let us allow to audit and they cooperate. That's
Millard,
only the prayer.
Audit with a document identification number, even if it is the issue number.
And
very well.
others, all others also,
And
there is
Millard,
a I
without
number.
any preconceived notion.
Every 4 notices we have given. So the time period, we have started the first notice on 5/5/2025. Last notice is 6/1/2026. So we have given a 1 hour,
Nahi.
1 year, more than 1 year. So 15
nahi.
days, because what is the intention
No,
of
no,
the
the time limit is
intention of the
already-
legislature is just to give the
Intimation and time to
yes,
prepare. them.
only the technical reasons. So now what they are saying, before conducting the audit, give us the reasons why 74 will be involved. How it can be? If the baby is not conceived and we are arguing for what will be it will be the female lady
Because
or the
due
male
to
lady.
their own observation.
No,
They
mine,
say 74 is available to them.
no,
Why are you
we
saying
are,
this then?
we are saying 65/7 has got the provision.
Followed by subsequent notices. For undertaking audit for the financial year from 2020-2021 to 2023-2024. In accordance with the provisions of section 65 of the CGST Act, 2017, within bracket as amended. Step. It appears that the petitioner all along objected to the conducting of the audit. Step. Paragraph. The learned single judge has recorded the apprehension of the petitioner that the authority may take steps under section 73 or 74 of the Act. Step. The court was of the clear opinion that it is improper on the part of the petitioner to come to a conclusion that on completion of the audit, CGST authority shall take steps under the aforesaid sections. Step. The learned single judge, without expressing any definitive view, disposed of the writ petition by holding the same to be premature and was pleased not to interfere with the impugned audit notice dated the last
6 January.
6 January to
impugned audit
2026.
notice dated 6 January 2026. Stop paragraph. It has been submitted by the learned advocate representing the petitioner that the authority ought to have mentioned the DIN number in the audit notice. Stop. Learned advocate representing the Union of India relies upon the circular of the Department of Revenue within bracket Central Board of Indirect Taxes and Customs, Ministry of Finance, Government of India, dated 23rd September 2025, which mentions that DIN number is not required to be quoted in communications.
Para 5 Millard, issue number shall be deemed to be the document identification number.
Yes,
It is not
definitely.
required to be quoted. And the issue number shall be deemed to be the document identification number. And such communication shall be treated as valid communication.
And which will be verified the petitioner from his mobile, laptop, anything.
It has been submitted that the issue number can be verified by the
Any electronic
taxpayer
displays.
through the mobile,
Through mobile, any electronic device.
or any electronic device. It appears from records that
The last notice does not bear even the issue number, Millard.
the notice dated 19th of November 2025 bears the issue number.
But that has become infructuous now. It is only the last notice which is in force.
Which page is this
My lord,
sixth?
page 42, 6 January 2026, which is the last notice. It is not in continuation, it is a fresh notice.
Lordship, there also they have given the notice which bears the I number. Because whatever they are submitting might be there due to the Xerox, it was not there. Because the department has supplied us. Because otherwise this notice will not generate.
Your copy does not have the number, but the number is here.
Every,
Very surreptitiously done.
and for my satisfaction, I have gone to my laptop, mobile number. I have
checked
just,
it up.
yes,
All
and
right,
I've
it's
taken a
there.
printout also.
Acha.
না,
Um,
print out হয়নি। সেটাই
Section
বলছি, কেন হবে?
65 of the CGST
উপরেরটা
Act,
কেটে গেছে পুরো।
2017 does not specify any time limit within which notice for audit can be issued. Step. The notice of audit can be issued. Now, the section clearly mentions that the commissioner or the section of section 65 within bracket 1 of the act specifies that, not specifies, lays down that the commissioner or any officer authorized by him, comma, by way of a general or a specific order, comma, may undertake audit of any registered person for such period, comma, at such frequency and in such manner as may be prescribed.
Lordship,
The
101
submission
rule.
of the petitioner that the notice to conduct audit for the period 2020 is time barred appears to be fallacious one. Stuff next. The appellant is now the appellant appears to have moved the writ court on the basis of apprehension. Stuff. Writ petition filed under apprehension cannot be held to be maintainable. Stuff. Next. In view of the above, the court is not inclined to interfere with the order passed by the learned trial judge, single judge. Stuff. The appeal accordingly stands dismissed.
Lordship, only the request that they should not object after that because they are giving the notice that you cannot conduct in the during.
No.
The
So
appellant
only the direction is that
the
let them
appellant
cooperate.
will be
Millard,
obliged to cooperate with the audit
Audit.
that will be conducted by the authority in accordance with law.
Millard, in any event, Millard, this date, 29 January 2026 is already gone. The statutory period to conduct the.
It has been mentioned in
So
accordance
Millard,
with law,
they
they
have to
will
issue a
conduct.
fresh notice
In accordance with law.
in accordance with.
It is-
তো জেরক্সের উপরটা চলে গেল।
Am I audible, my lord?
Yes.
Item 10, my lord. My lord,
I am
item
for the
10,
dependent, my respondent dependent.
my lord, Mr. Orup Ratan Chatterjee appearing for the appellant, my lord. My lord, now he is in Kolkata for his mother treatment, my lord. So, my lord, I am paying only, my lord, next circuit, my lord.
In one hand, my lord, suit was dismissed. Other hand is a lawyer. He's taking the possession of my land forcibly. I have lodged a complaint. My lord, this is shoot for a declaration that the oral agreement is binding upon us, and for a specific performance that I should make a deed of reconveyance or transfer of the land in favor of the original plaintiff. Suit was dismissed. After dismissal, they paper the appeal. My lord, some delay also. There's some defect also. Can you see? Report.
Okay. I see there are, no, we see there are defects in the appeal. Has the defect been cured? Your appeal has not yet been registered.
So there's some,
My lord, the deficit court fee has been deposited, my lord. It is my instruction.
Positive.
20 se bolche deficit court fees has yet been received by the department. এখানে বলছে 12/5 তে I have deposited court fees. How can that be?
Report আছে। Deficit court fee has been deposited.
Has been deposited?
On 12/5.
Then
That
this
is
is
beyond the
20th.
period.
So the court permitted. All right. What to do? Mr.
My lord,
Ray, there is a request for adjournment.
so.
My lord, Mr. Chatterjee's mother is serious ill. His mother
So
is.
then I can't object, I can't object one. I can't
Next,
object.
sir.
It has been submitted that the mother of the learned counsel representing the appellant is seriously ill. The accommodation has been sought for. On such prayer, this is the matter in the next circuit.
Yes, sir.
Lordship, can you fix this matter on next week, Lordship? The paper
Next week,
next week. Paper book's ready, Lord. It's laying on press for binding, Lordship.
Next week, kindly make it preemptory. They're enjoying a stay order.
No issue. We do this matter next week, Lordship. Mr. Kushal Chatterjee will appear in this matter. We will do this matter, Lordship. Paper book
the
is ready.
prayer of the learned advocate for the appellant, list the matter next week.
Grateful.
We got it. After biplop the. I'm not 12 for the petitioner.
I am for the opposite party.
No, Lordship. Fact of the case is that
What is the application for?
application.
There is one can one.
Condonation? No. I think
No.
condonation. Delay was condoned, direction, matter was admitted, appeal was admitted, direction for preparation of paper books, we have prepared the paper book. এটা তো নেক্সট ভুল করে লিস্ট
Talks of settlement was going on.
it has failed.
Mallory,
It has
Failed.
Has the can been disposed? I can see the can running all along. What is the can for?
Stay. Stay alone. Stay.
Can 2.
Can 2 was for section 5.
Can 2 has been allowed.
Yes.
But the stay is pending.
Yes. Lordship, when paper books have been prepared, Lordship, the entire thing can be disposed of.
Yes, certainly.
Yes, ma'am.
All right, place it.
Lordship, the next circuit. In the meantime, most of the advocate was appeared earlier occasion, they appeared for the party.
For the
Millard, may I suggest this, Millard? There was a direction upon the state to file an affidavit. All the records pertaining to Millard, the arbitral proceedings are annexed. My lord, next week, kindly, my lord, fix up a date according to their convenience when this matter can be heard and disposed of.
Can be,
There's no point dragging it further. my lord. It's-
able to, my lord.
He doesn't have the papers also, he says.
No, my lord, this defense, my lord, is briefs are there, it has to be reallocated and.
But Lordship, someone should be present the state because the Mr. Mishra is once upon a
Cannot
time
appear.
yes. And
My lord,
Mr.
now there are sufficient people in the panel, my lord. This cannot be a ground, my lord. Next week, any day, subject to their
Yesterday,
convenience.
my lord, the panel has expanded. I think, my lord, my learned friend will also consider it for the proper adjudication of this case, my lord. We had tried to.
Please come.
I'm
The,
grateful.
in view of the change
No, no,
in the panel for the state councils, the present learned council who has been engaged is not in a position to argue the matter today. So prayer has been made to fix the matter in the next circuit. So in view of such submission, released in the next circuit, stop the parties shall come ready for hearing.
And my lord, outside it, my lord, we are sending it to the learned government leader at the principal bench to engage somebody, because here most of us in one way or the other are involved in this case, my lord. Great.
See if somebody from Calcutta can.
Yes, we will do that one. We will request the learned government leader there to engage council.
All right.
Milord, 14 Milord is an appeal that section 11 of the 1952 Act against an arbitral award. But there is a delay, Milord, of about 14 days. The condonation application is being affirmed today, Milord. Kindly takes it up in the next week. Only for admission. Milord, the union has also preferred an appeal against the same award. So both can be, this can be admitted and tagged with it for them, and they can file their paper books during the next circuit.
So next week,
Milord, any day, Milord takes it up, Milord. Only a formal order of admission.
not this week, not this week.
Monday.
Huh?
It's not
37.
Like that. Order record.
I am appearing on behalf of the respondent number 1 and 2, my lord. My lord, I am praying for liberty to file affidavit in opposition, my lord. Your lordship, my lord, coordinate bench has passed an order dated 12th June, my lord. My lord, with dispense from paper book and calling of record, my lord. With leave is granted to the appellant to reply on further documents at the time of hearing, my lord. My lord, we also want to file some further documents, my lord. That is why, my lord, I am praying for liberty to file affidavit in opposition only for 1 week, my lord.
So far, my lord, the documents are concerned, my lord, that those are relied upon by the parties with the court below, that can only be considered at the time of hearing. We are the if my learned friend wants to file opposition, let him take the place. If there is a reaction, so we can also apply for reply, matter replace with the next circuit, my lord.
My lord, am I audible, my lord? I am not.
Yes, yes, the court can hear you. Please come.
My lord, I am audible also.
Learned advocate representing the respondent numbers 1 and 2 seeks time to file opposition to the application filed by the appellant. Stop. Let affidavit in opposition be prepared and circulated within a period of 2 weeks.
One week, my lord. Only 1 week. My lord, kindly
Take another
keep this matter Thursday, my lord.
Reply. How can it be on Thursday?
Reply, my lord, I'm taking with 3 or 4 days. Can you please reopening circuit 20th or 21st? Because I pray my lordship, if the document is supplied to us on Monday, please will take 2 or 3 days.
2 weeks, 1 week.
2 weeks, 1 week.
List in the next available circuit.
2 weeks. 1 week, my learned friend will take 1 week, my lord.
2-1.
My lord. 1 week, my lord, he is asking for 1 week.
Acha,
That is
1-1
why,
kore
my
din.
lord, I'm praying.
1-1.
1-1.
1-1.
Then I can
All right.
attend the next circuit. Otherwise, it will
All right, all right.
get food to your
1-1.
lordship.
I don't know why it has come under order 41 rule 11. Milord, it's showing defective. Milord will see the defects. Milord kindly takes it up on Monday.
The equivalent of the implement and facing clustering the SR report mentions about defect in the filing of the appeal stuff. The appellant is directed to take steps to cure the defects. List next week.
On record corner. Tum check karo. My number.
Lordship, I'm praying for fixing this matter on next Wednesday. Mr. Shah is in this matter. He'll be moving.
No, this is subsequently 2 days they are seeking time.
No.
Same matter.
They simply want expeditious disposal. Now, that is something that can be done
Expeditious disposal of the application before
before
the
the tribunal.
but the tribunal is non-functional. The state administrative tribunal is not functioning. What no?
That
State administrative tribunal is not functioning.
Yes, I'm aware. That is the reason writ petitions are hard.
My lordship.
Then
They have a list there that is pending from 2015.
Yes, my lord.
2015.
Yes, my lord. It is still not.
Take steps. Let the tribunal be made functional. We are keeping it in the next week. You inquire and see what is to be done.
But in that case, my lord, may I just point out one thing?
Yes.
I was going through the order sheet. In the last 1, 2, 3, 4, 5, 6 occasion, there was none for the appellant.
And because there is nobody in the tribunal,
My lordship.
have you followed?
But it was
writ
always
petitions-
fixed for hearing.
All writ petitions are being filed.
My lordship,
Only because the
I'm aware.
tribunal is not.
I'm aware of that.
So you please ensure that the tribunal becomes functional and the matters can be relegated over there.
My lords can pass an order. I will let the higher authorities know. That is all that I can do. Because my lords knows how the
And this
appointment of
is-
tribunal
I know,
has to happen.
But then this is the prayer for expeditious.
Yes, my lords.
There is subsequent prayer also for pro rata pension of the.
That is on merits.
Yes, yes, my lord.
That is on
Yes, the main prayer is expeditious
The
disposal
lordship
of
can
the.
hear on that also, my lord. That's why I'm seeking for time.
Otherwise, not the pleading are complete before the tribunal. It was fixed for final hearing from 2019.
Thereafter,
From
there was no
1990
judicial
it
member.
was functional.
No, my
Judicial
lord.
member was
Judicial
not
members
there.
were not there. And repeatedly, we have also annexed the advertisement regarding the recruitment of other members and judicial members. It was not functioning. That's the problem.
Otherwise, this is a very simple case, overdrawn case. Rafiq Mashi Waterman, that case would be
Can we
there.
set it aside and send it back?
No, my lord.
That will not help them.
That kindly
Will not.
Because the report is there, everything is there before the tribunal. The final hearing, it was fixed for final hearing in 2019. And since then, it is always running for final
Can
hearing.
we hear it and finish it off?
Yes, my lord.
That can be done.
Yes, my lord.
If you say it is
that can
settled,
be-
Rafiq
yes,
Mashi
yes,
is
yes.
there, what is the use
Rafiq Mashi
of,
is there. Mothers can have it tomorrow. I will, because today I was only on the expeditious disposal.
I understand.
That will help him.
Right, because
Yes.
he
Somebody
is
suffering from
wanting-
2015.
Wanting pension, he is 82 years of age.
I understand that. Mothers can kindly
Let
keep it
payment be
tomorrow.
done.
Around.
We are giving something in your favor.
Yes.
Ah,
Then tomorrow,
Tomorrow,
my lord,
first item for
Minister-
the day, we will prepare
I'll
and we
convey
will
him.
come.
He will appear online, my lord.
we make it only not today. Whoever is there, tell them to
Yes,
come
yes, ma'am.
prepared. Mr. Mishra will be here. We'll finish it off. Whatever
That
is
way,
there.
I am also safe because the
Grateful.
tribunal order is not
I
there.
understand. I understand the difficulties.
My lordship.
Grateful, lord.
My lordship. I am deeply obliged.
18 Lordship, I am appealing for the appellate. My lord, the order impugned is the passed by the learned West Bengal Land Reforms and Tenancy Tribunal. My lord, before that, my lord, in a very nutshell, my lord, the matter, the fact of the case was the appellant's mother in 1964, my lord, applied for the long-term lease, long-term settlement because my lord, her land, my lord, has been, my lord, she became homeless because of the erosion of river Tosha. Page 43 is the lordship, the application by the mother of the appellant, that is in the year 1964 for long-term settlement to the government. Thereafter, lordship straightway kindly comes to page 48. This memo has been issued in the year 1992 pursuant to the applications of the mother of the appellant, where my lord, the sanction was accorded with regard to the long-term settlement in favor of the mother of the appellant. September 1992. Lordship kindly comes to the next page. Unfortunately, in the year 1992 February, the mother of the appellant, my lord, expired. This is the death certificate. 26th of February 1992. Now, lordship, the page 50, although they were asked, the mother was asked for deposit of rent and salami, but since she died, that could not be done. In place of her, page 51, lordship kindly comes. The appellant, being the only legal heir of the mother, my lord, she applied, she filed, she submitted this representation and her willingness that she wants to deposit the assessed amount and wants to continue the prayer of her mother with regard to the long-term settlement. Now, lordship kindly comes to page 52, 53, lordship kindly comes. This is the letter of the ADM District Land and Land Reforms Officer to the Principal Secretary, page 53, second paragraph, lordship will get it. In pursuance to geo number such and such, it is therefore moved with request to accord sanction towards long-term settlement of the land with Srimati Geeta Bonik, she is the daughter, for 99 years with effect from 1371 BS for homestead purpose.
Thereafter, it has been rejected?
No, not rejected. My lord, lordship kindly see. The sanction was accorded in the year 1998. This letter has been, my lord, the daughter, my lord, made the representation in the year 1997. These steps has been taken by the respondent authority in the year 2006. Thereafter, lordship kindly comes to page 54.
Yes.
In the year 2015, lordship kindly notice the gap. 2015, the SDLRO wrote a letter to the revenue inspector to settle the issue, that is on 6th of January 2015, that after 9 years. So these are the long gaps between the steps taken by the respondent
What
authorities.
is the problem now?
They did not take any steps.
Why did you go before the tribunal?
Therefore, I filed the application before the tribunal.
All right. What is the order passed? by
Now,
the
lordship, in the during pendency of this order, pendency of this way application before the tribunal, the respondent filed the report, one report. Lordship kindly comes to page 70. In the report, page 70, lordship.
Yes.
In the report, the last paragraph, lordship kindly comes to paragraph 5. That as per order dated 26/8/2022 of the Honorable LRTT, a hearing was held on such and such in the chamber of such and such. My lord, that as per order dated 26/8/2022. Now your lordships kindly comes to the order of the Honorable Learned Tribunal dated 26/8/2022. There was no direction upon the respondent authority to conduct a hearing. Lordship kindly comes to the certified copy, the first order, 26/8/2022.
Right now, there is no provision for grant of 99 years lease, and it is only 29 years lease that can be granted.
No, my lord, their notification says the 99 lease can be granted.
There is no provision for
For
29 of years.
for which lordship I have been, my lord, I have been aggrieved by the order of the Learned Land Reforms Tribunal, Lordship kindly comes to the order dated 26/8/2022 passed by the tribunal.
Page.
No, my lord, this is the certified copy. First page.
All right.
First page of the order. That hearing took place according to them pursuant to the order passed by the Learned Tribunal on 26/8/2022. My lord, I am reading the order. Lordship has got it, the
No,
order.
no, we've not.
26/8/2022. Just after the page 116. After the
Internal page of the judgment.
Lordship,
Internal page.
page 116. Just after the page 116. My lord, the learned advocate such as such appears on behalf of the applicant, government representative present. Government representative files a status report, also files 2 notifications such and such. At this stage, learned government representative submits that on behalf of state supplementary status report required to be filed. So opportunity may kindly be given to answer that very submissions. Learned advocate for the applicant submits that if prayer for time is granted, then there is a chance of forcible dispositions of the applicant. So some protections may kindly be given to the applicant. Consider the submissions of the both sides. On consultations of the Amin's report, page 38, annexed at P10, it appears to us that the applicant is in possession of the suit plot since last 40 years. In such circumstances, we are of the opinion that the balance of convenience lies in favor of the applicant. As such, parties to the proceedings are directed to complete status quo in respect of the nature, character, possessions of the plot in questions only with regard to the area which is in possessions, which in as per way till next state. So, my lord, there is no such direction upon the respondent authority to conduct the hearing during pendency of the original application. The respondent authority, what they did, they conducted a hearing, saying that as per the order of the Learned Tribunal dated 26/8/2022, but there is no such direction. And after the conducting the hearing, they said that the appellant is not entitled to get the long-term lease for 99 years.
What is the reason for not?
Lordship kindly comes to the order. That is page 84. Lordship has got it. Lordship, reference Lordship kindly see, order dated 26/8/2022 of the Honorable WB LRTD. In that order, Lordship has seen, my lord, there is no such direction to conduct hearing by the respondent authority. Even then, they conducted hearing and passed this order. As per existing government rules, there is no provision of sanction of LTS of piece of land in favor of someone for 99 years with salami and annual rent calculated 29 years ago, and he or she has to pay salami annual rent on current valuation made
What
by
is the provision for?
Yes, my lord.
obtaining
They have,
long-term
my lord, annexed the notification. Lordship
Yes.
kindly comes to page 107. Roman 1, Lordship kindly comes. The land allotted to individual, company, institution, etc. under the policy would be transferred to them by the government and its parastatals by way of long-term lease for a period not exceeding 99 years. So 99 years can be done. Not exceeding 99 years cannot be done.
Long term can be done, but their demand is from.
Yes.
From the
They
date of
fresh
evaluation.
valuation. But my application was pending since 1997. 1997.
First
My lord, my application, they did
They
the
forwarded
delay.
the year
By
2006.
they did the delay for my lord, they took steps within a gap of 9 years, 10 years. Now they have come. First of all, they are saying that 99 years lease cannot be granted. Secondly, if it is granted, you have to pay the
Current
salami
market
as per the present market rate. Now, Lordships kindly comes to the judgment passed by the Honorable Learned Tribunal. My lord, it's a long judgment, but the entire judgment with regard to the submissions of either the appellant or the respondent. Lordship kindly comes to the last 2 pages where the observation of the tribunal. Tribunal says that since the representation has been considered By the way, by conducting the hearing, therefore tribunal has nothing to say. Tribunal did not go to the merit of the case, although my prayer was, my lord, otherwise. Lordship kindly comes to the inner page of 11 of the judgment of the tribunal. The entire order, my lord, the submissions of both the parties and the annexes which have been placed by both the parties before the tribunal. Now, Lordship kindly comes to the inner page of the tribunal. Inner page 11 of the order of the tribunal. Lordship has come to the page number 11. My lord, I am reading the observation, the paragraph. The annexure H reproduced about actually divulges the fact of the applicant's representation dated 3/4/1997. From the status report and its annexures, it can be concluded that the representation dated 3/4/1997 has been considered by the appropriate authority on 28/12/2022, nearly about 25 years from the date of submissions of the representation. Such inordinate delay highlights the bureaucratic nullance of the highest order. We have no doubt that grant of long-term settlement of a piece of land in favor of an individual is the exclusive prerogative of the government. But at the same time, we are of the view that such prerogative shall be exercised judiciously in accordance with law within reasonable period. Hence, the state authorities had been slumbering over the representations of the applicant for nearly 24 years, and suddenly they woke up at the intervention of the tribunal and took nearly 3 years to decide the fate of the applicant's representation dated 3/4/1997. In a welfare state, such deliberate inaction on the part of the public servant concerned is very much shocking and painful. In fact, the authority concerned is under obligation to dispose of such representation without unnecessary delay. This is the observations of the on the learned tribunal. Thereafter, as the representation dated 3/4/1997 of the applicant has ultimately been considered and disposed of, we find no scope to issue further direction in the matter of disposal of the said representation stated such and such. The instant original application is just disposed of. So tribunal did not interfere, saying that the representation has been considered. Representation has been taken care of on the basis of the hearing.
Tell us one thing, come to page 50.
50.
There was a direction upon your mother to pay the rent and salami in the year 1993.
Yes.
She expired prior to that.
Yes.
Next comes your letter in 5051.
Yes.
In 1997, page 51.
Yes.
From 93 to 97, there is nothing.
No,
From your
that I
side.
admit. That I admit there was nothing.
Next comes 2006. From 97, it goes on to 2006.
That 2006 because of this, the respondent authority. They took steps in the year 2006.
52 is your representation.
52 is my representation. No, Lordship. 52, 53, their Lordship kindly comes to page 53.
2006, it is their communication.
Their communication to the principal secretary.
Right.
So they took 9 years. Thereafter straightway they took steps in the year 2015.
In the meantime, the 2012 notification came into play. Right.
My humble submissions before your Lordship. The tribunal has disposed of my original application without considering my prayer, without interfering, just taking into consideration that the representation has been disposed of. Therefore, tribunal has nothing to do.
No, but then the fresh order that has been passed has not been challenged by you. Well, let us hear what.
First thing first, my lords, if I can have my lordship for a moment, because she has already done that, but still for my satisfaction, lord, page 48.
Yes, 48.
48, my lords, happens to be the initial letter for long-term settlement. It was in the kind of an offer. It was a conditional offer. If I can read it for my lordship. In the subject, not to find that the name of her mother is there, Srimati Kumudini Banik. So it was referred to Kumudini Banik. The contents of the first paragraph says, District Kuch Bihar with Srimati Kumudini Banik for the purpose of homestead as a salami of 7,110 only, and at the annual rent of 711 rupees only by the lease, subject to realization of the salami. So it was a conditional offer. If she would have deposited it, then it would have been considered. Now, the travesty of the situation is, in the next page is the death certificate. That she died in the month of February 1992. The
Prior
letter
to
was,
issuance of-
yes, she predeceased the offer itself. Now, if there is a foundational thing that has went wrong, then it cannot be corrected subsequently.
It has been corrected.
No, it hasn't
The
been.
later stage.
No. That is what I'm trying to explain. Now, what happens is, there is a reminder that is sent at page 50, because the authorities isn't aware that the person in whose favor it has to be granted has already predeceased. Then what happens is, then thereafter, Geeta Banik makes an application at page 51.
Yes.
She says that she is willing to do it. Now, obviously, the authorities, because the original person who has applied for the long-term settlement, she has predeceased the offer itself. Therefore, it was considered at page 52. Yes, there is a delay, but this is taken as a fresh, because the previous one, it could not be.
That is the way it has been corrected.
It hasn't been
Type of-
corrected. What the authorities here say is that it will be in the nature of a fresh long-term settlement.
Whatever.
So she need to apply fresh. Now, if she has to apply fresh, she cannot claim the rates of 1992 because the rate of land keeps on
In
increasing.
2006 also, if the rate which was available in 2006 is taken, then also she is saved of the 2012 rigors.
So then what she does is, because if I can have my notes for a moment from page 53, she was asked to deposit 1775 for 99-year settlement along with the annual rent of such and such.
Which
But
page?
she insisted, 53, the offer was there. But she insisted that no, we want it as per 1990, where she says that at page 56, paragraph number 6, that is where the issue
may
is.
be considered at 17,775
yes,
for
yes.
19.
So the revised salami and revised rent were claimed from her.
That amount may be paid from.
She do that.
No,
What she does is,
was
page
it
56.
sanctioned? It is
It
next
is only
paragraph says it is
proposal.
moved for
It is
sanction.
proposal.
So, but then till it is sanctioned, she will
Page
not be in a
56,
position.
page 56, paragraph 6 for a moment.
Page 56, paragraph 6.
What is the contention of the present petitioner? She says that I am ready to deposit the rent, salami, etc. to such and such, by such and such, at the rate of 1992. So she is still insisting that I will pay it at the rate of 1992. That is where the issue is.
Issue will, in 1996 rate, will you permit her? Page 53.
No, because
2006.
that time has also elapsed now. Now there is a new
Where is the
policy.
sanction? Page 53.
My lordship.
Second paragraph, in pursuance of such and such, it is therefore moved with request to accord sanction towards. Till the sanction is allowed, page
How she will
53,
pay?
how will she pay?
This is a little illegible, but what I can figure out from here is that
In pursuance of second paragraph, we are reading in pursuance of geo such and such, it is therefore moved. Who is moving? The ADM DLLRO. It's
with
moving
request
before the
to-
principal secretary with a request to accord sanction towards long-term settlement for Geeta Bonik for 99 years with effect from 1971 for homestead purpose. 13,790. How can it be 13?
BS
For homestead
homestead.
purpose. So till the sanction is granted,
How
how
she
can
will
she deposit? To accept 2006 rates? How will you had proposed before the secretary for sanction. It is at that stage, nothing came. She went to the tribunal. In the meantime, the new law comes in, the land allotment plan and 2012.
yes, because
rate is-
she always insisted upon 1992 rates.
Forget 92.
My lordship.
Will you permit? What is the fate of this page 52? There is no conclusion to page 52. No request, the proposal is neither disallowed nor it is accepted. If you say it is not sanctioned, the matter ends. It's a fresh cause of action.
But it
You
is
don't do
still
that.
pending.
You keep it,
Pending.
her later representation is considered and applying the new rates.
Then come to 61 for a moment, my lords. As per the new rate notes, our demand now was in 2017, because she didn't pay it, our demand was that now you have to pay 63,030. Then also she again says that no, I will pay it as per 1992 rates.
Maybe. She will want it for free. Nothing new about it. But the thing is, whatever the applicable rates, you can certainly charge her according to that. But what is the conclusion of page 52? and whether the fate of page 52 was at all intimated to the petitioner. The matter ends there. Thereafter, she did not accept. 2012 new rules come in. The land allotment policy is there. The petition will be bound. But then, what is the fate of page 52? 1300 নয়, এটা 1971.
Proposal may be.
It was a request that was made.
It was a request.
She did not comply with it. She insisted upon.
Where is the request?
Oh, the request is there in page 52 and 53.
Oh, that is not a request to her. This is a request
Principal
by
Secretary.
the
Request to accord sanction.
accord sanction to the principal
That
secretary.
was not done.
Show that it was not
We
done,
will,
that it has been refused. We will not grant sanction.
we will do that.
The moment you refuse to accord sanction, her right goes. She
Yes.
is either required to challenge this communication, the information that you refuse, the refusal is to be challenged. And then page 54, the new land allotment policy comes into play.
What would be the English calendar if we calculate 1371 BS? What would be the year of English,
1371
as per
BS
English
in English
calendar?
calendar দেখো। আরে গুগলে
Oh, I think that is again been referred to as 1992. Most probably. I need to check it out.
Yes, that will be the date when the first application
Yes.
was made.
Proposal was in 92.
সেই ওইখান থেকেই তো বলছে। Please come.
আপনি করা যেতে পারে, this rate should be applicable on the date of application or representation by the user.
That they will.
মারা গেছে।
মা মারা গেছে, তারপরে যেটা 2006 এর প্রপোজাল বানালে সেটা তো আর কিছু নেই। It is a proposal in favor of
এটাই আমার ধরি, this rate should be the actual rate.
1371.
There is another problem, Lords. My instruction is that as on today, the land is not in the description of land has changed. It has become a road now. So even otherwise, it cannot be accorded to.
No. They are
She is in possession, status quo was given.
No, that is a different.
They are in.
There is a
my
different.
specific
We will file a
instruction-
report. We will file a report.
My specific instruction, they are in possession. The Gita Bonik is in possession, Lordship.
It's a homestead land, it was mentioned,
2 decimal of land,
decimals of
I know.
land, not much.
not much.
Uh,
And residing there for 40 years, this is a place called home for them. I understand that. But we will file a report.
according to the
1971 BS in English calendar. Mid-April 1971. ये तो আছেই তো।
1971 হচ্ছে। ও তাহলে ওই অ্যাপ্লিকেশন করেছিল 71 থেকে করেছিল, তখন থেকে করছে।
দেখি কি হয়।
sanction was issued in favor of the mother of the petitioner. Expired.
Conditional sanction. She had to deposit the salami and everything.
Expired.
No, the terms and condition of that offer letter wasn't carried with.
26.
26 February 1992. A reminder was given to the mother of the petitioner for deposition of rent in February 1993. The petitioner, claiming to be the sole heir and legal representative of the
This is Kumudini Bani.
deceased Kumudini Bonik, applied before the subdivisional land and land reforms officer, expressing her willingness to take settlement of the long-term lease, a long-term settlement
19 for
in her
99.
favor for a period of 99 years. The ADM and DLLRO HPR, by a communication dated 16th of May 2006, requested the principal to the government of West Bengal Land and Land Reforms Department, requesting to accord sanction of the long-term settlement of the land in favor of the petitioner for a period of 99 years for homestead purpose. Stop. Since thereafter, there has been no communication from the end of either of the parties. Stop. By a communication dated 6th January 2015, the subdivisional land and land reforms officer Shodor Kuch Bihar intimated the revenue inspector Kuch Bihar municipal area with a copy to the petitioner about the settlement of the matter. So, as the same remained unsettled, the petitioner approached the West Bengal Land and Land Reforms Tribunal, Land Reforms and Tenancy Tribunal.
There was
by
another
filing-
proposal made at page 61 of 2017.
Sorry, 15, yes, 17 and 17. So very illegible.
Yes, but the amount is somewhat clear. It is 63,030.
This is also to the principal secretary. Not a
As
proposal
per
to
new
the
policy.
petitioner.
Acha. A further proposal by the the additional district magistrate and the district land and land reforms officer Kuch Bihar, by a further communication dated 2nd May 2017, addressed to the principal secretary, isn't it?
Principal
Yes.
Secretary.
To the government of West Bengal Land and Land Reforms Department.
For 30 years, yes.
Proposed for the long-term settlement in favor of the petitioner. This period
30 years. In the first line,
Yes, as you can-
for a period of 30 years. At a rental, is it rental or salami?
annual rent and salami.
Rent and
Rent
salary.
and salami at the rate of 12.05, 071.
No, my lords. That is the market value in the
It's 63, isn't it?
60. Yes, 61 million.
63.
63,030 rupees.
070.
Rate salami is 63,030.
030.
And something is there, cannot read.
That is not clear.
As per the provision of Rule 223 of the WBL and LR Manual 1991. So, as they have been remained unsettled, the petitioner approached the tribunal by filing OA number 1383 of 2021. In the said original application, the status report was filed by the ADM and JLR of Kushihar, signed on 13th of October 2023, mentioning that as per the existing government rules, there is no provision to sanction long-term settlement of a piece of land in favor of someone for 99 years with salami and annual rent calculated 29 years ago. Stop. The authority rely upon the order dated 26th December 2012, being the current land allotment policy.
No, my lord, the order dated 26/8/2022 is the order of the tribunal.
Allotment policy for grant of long-term settlement, long-term lease for a period of 99 years at the present market rate. Stop. Where is the order of the, there is an order of the authority, isn't it?
Yes, ma'am. 84.
Page 84.
84.
This is the order of the hearing.
Yes. It's the same thing. At the time of final hearing of the original application, the tribunal noted the stand of the state respondents and disposed of the matter by observing that there is no scope to issue direction upon the authority concerned in the matter of disposal of the petitioner's representation dated 3rd April 1997, as it has already been disposed of by the competent authority. Specific case of the petitioner is that the authority ought to have considered the presentation, the request of the petitioner for grant of long-term settlement in terms of the application made in the year 1997. Stop. The rent and salami prevailing at that point of time ought to be taken into consideration for the purpose of settlement of the land. Stop. The authority ought not to have applied the current market valuation and the rent as per the land allotment policy adopted by the state on 26th of December 2012. Prayer has been made by the petitioner to set aside the order of the tribunal and direct the authority to calculate salami and rent for the subject plot of land which the petitioner is occupying since 1992 and prior thereto. Since prior to 1992. To 1992. So, the learned Triple AG opposes the prayer of the petitioner. Stop. It has been submitted that due to passage of time, the description of the land has changed. Stop. According to the state, the land is currently being used as a road for public purpose. Paragraph. It has also been submitted that as the condition which was sanctioned for release in the year 1993 was not complied with by the mother of the petitioner or by the petitioner, accordingly at this stage, there is hardly any scope to grant settlement in favor of the petitioner, relying upon the said rate. Stop. Paragraph. To ascertain as to whether the subject land is currently in the possession of the petitioner as claimed or is being used for public purpose as a road, let a status report be filed before this court on the adjourned date of hearing. Stop. A spot inspection shall be conducted upon prior notice to the petitioner to ascertain the status. Stop. The report shall also indicate the fate of the proposal which was forwarded by the ADM and DLLRO Kuch Bihar to the Principal Secretary on 16th of May 2006. Stop. If the proposal remains undecided, then the authority shall answer as to why the rate prevailing on the said date will not be made applicable for grant of long-term settlement in favor of the petitioner in respect of the land which the petitioner claims to have been occupying prior to 1992. Anything else to be
is denied and disputed by the petitioner. The land is used as a homestay. Road use, land is used.
The said contention has been specifically denied by the Honorable Advocate for Education. Any other thing which you
Just one thing, Lords, my Lords, are just while taking the order, said 1993, it would be 1992 at one of those places.
Last the
Communication is 1993.
The first proposal was 21/9/1992.
other died in 92 October 92.
Page 48.
Any other point which will be required?
No, but I will request the authorities to look at compassionately based upon the fact that this is a
That
place
is
called home.
up to
That
you.
is that
At
we will
this
see.
stage, the court will not
No,
dictate that.
no.
Okay,
If you come back, inspection is to be conducted because you say it is a road.
In their presence, yes.
Yes,
No,
and
no,
it
they
is
are
to be
staying
done.
there. They are staying there, Lordship.
Has let a report be there.
Yes, yes. A copy, the
List in the
inspection may be
next-
done, Lordship.
List in the next circuit.
I'm obliged.
Affidavit of
Can-
service. What
can-
is that?
Affidavit of service.
Affidavit of service. You take it.
If it can be, my lord, accommodated by your Lordship in the next week, Lordship.
Inspection.
Thursday,
Cannot be
Friday.
done within,
If the
Inspection
inspection
it
is
is very-
waived,
very
if you
difficult.
say that the inspection is
No,
waived,
no, no. No, my lord. I want inspection. I want inspection because, my lord, I am 100% sure that there is no road. My lord, they are staying. My lord, inspection.
The way the order has been dictated, everything is going to go in their favor. It's just a matter of time.
try to
Ship.
see if something can be done.
Yes, my lord. It's a genuine prayer, Lordship.
Lordship,
Gratefully, your Lordship.
Deeply obliged.
Lordship, may I please, Lordship? Lordship, before your rising, Lordship, the item number 29, my learned fellow brother, his better half has been gone for surgical operation today. So if any day of next week, as per convenient of your Lordship, Mrs. Shionovi is appearing in the same matter. করবে না।
My lord, it was relisted on my lord 9th of July, my lord. My lord, if lordship wishes, my lord, it can be taken up tomorrow, my lord. I will do the my lord matter. My lord, it would be very difficult because very old matter, my lord. My lord, kindly let it be taken up tomorrow, my lord. My lord, kindly, my lord. My lord, day after tomorrow, my lord.
Item number one.
My lord, item number one, I'm praying for not this week, my lord, because conducting advocate is out of station for the time being. My lord, for the same reason. Then, my lord, one day accommodate. Then, my lord, make it for not make it not today, tomorrow. Keep the matter tomorrow. I'll.
Item number two. Item number three. Item number three.
My lord, I am for the petitioner, my lord. I am coming before your honorable court second time, my lord. Previously, my bail was placed and rejected on 17/3/2026, my lord. And my ground for this bail before your lordship is that there were three accused, my lord. Two are on bail, my lord. And one accused was on bail, enlarged on bail, considering the ground of arrest, my lord. And previously, my bail was rejected on the ground of arrest only, my lord. That it was mentioned in the memo of the arrest. But I can supply the judgment also in this regard, my lord. And another
was considered last
my lord. And now, my lord, this there is no trial evidence that last date was fixed 9/10/2025, my lord. There were several guns. My lord, they are in jail without trial, my lord. And two are in outside the custody, my lord. And witnesses are not coming to the courts, my lord. Obliged.
Lordship, praying for not this circuit. Next circuit, Lordship. Next circuit, Lordship, praying for Lordship. Lordship, short password, Lordship.
Lordship, for item number 3, Lordship, I am praying for short password. Matter has been dismissed for default, Lordship. I was in court number 5, Lordship. If it can be make it short, yes, Lordship. Lordship, my senior is in court number 5, Lordship, moving the matter. We will move, Lordship. Kindly make it pass over. Grateful, Lordship.
Yes, I'm with him.
Two ground, my lord. Number one, there is a violation of that previous rule I referred, clause 13, and number two, ground of arrest. My lord. My lord, that is on the instruction of the petitioner, my lord. Right, my lord. I was specifically instructed actually, and now he is also medical ground is also there. He is seriously ill. My lord, no, there is, my lord, there is a ground of arrest that is a very clear violation, my lord, and Supreme Court has mandated that it has to be mandatorily followed, my lord. If my lord kindly comes to my running page number, my lord. My lord, if my lord kindly comes to page number 14, my lord. She's a lady, my lord, and there's medical ground also. Take to them. She's seriously ill several times. She needs to be treated in a proper facility. My lord. My lord, he has got ulcer in the stomach and seriously. It was not, it could not be treated in the medical facility that is provided with the jail authorities, my lord. Several times we have been sent to the North Bengal Medical College. But no treatment has been, no effective treatment has been done, my lord. My lord, that is number one.
Page
Another ground, my
page
lord.
25 grounds of arrest.
My lord,
For that lordship made, he has got other recourses too, madam. Here are other recourses. The medical facilities are provided, but I have
No, my
to
lord,
check with respect to that, because in a bail application I cannot say right
that
now
is
what is the
very
status.
unfortunate. In several times it happened that
Page
I
25,
asked to the court repeatedly that medical facility not provided, but within 15 days,
25.
15 days they expired. It happened, and that is very much unfortunate on our part, my lord. And regarding ground of arrest, my lord, that memo of no ground of arrest has been provided to us. Only memo of arrest in which she signed in Bengali, and this is the judgment, my lord. We have never been provided that. We have never been. My lord, is it maybe, but it is in English, my lord. It does not know. Yes, she signed in Bengali, but everything is in. It has to be.
Maybe it is very necessary. Every 14 days. Every 14 days.
My lord, we have never been given that. My lord, it has to be in a language.
Having some issues.
Just consider his medical condition, my lord. Even an interim bail, my lord, for treatment. We have never been provided, not in the charge sheet. Medical college and hospital.
Guest ready? Much.
No, time for
City नहीं, city नहीं, city नहीं. Actually नहीं होगा. Next week करो. Next week करो.
Yes, ma'am.
My lord, item number 10, CD not available. Not my lord.
Next week. Next week.
Kindly fixed it on next week. Date for me.
CD.
On item number 11, paying for next circuit. My lord, the conducting advocate is my lord appointed as state advocate. My lord, for this reason, I'm paying for next circuit, my lord. My lord, এটা পার্থপ্রতিম সরকার।
Reject करो.
My lord, I am Sundip Gora. He is a, yes, ma'am. He is a conducting advocate, my lord. My lord, he is a conduct. My lord, then my lord, kindly fixed it on the next week. I will make alternative arrangement. My lord, this is a NDPS case that any day in the next week. my lord. Good. Next. My lord, 12 is also same conducting advocate. Same advocate. my lord. Good.
City ছিল না আগেরটা ছিল ছিল
Item number 13.
12
Item number 13.
12 টা
Lordship, I am on behalf of the state.
12 টা 12 টা দুটো সিটি আছে কি হলো This is not important. Choose.
Item number 14.
Lordship, I am for the petition. Lordship, the petitioner custody more than 130 days. 130 days, and charge sheet has been submitted under section 20, subsection B. Charge sheet has been submitted. Total 59 kg, 9 kg, 800 gram ganja. Lordship, kindly see annexer P4, page 24, 21. The memo of arrest. Lordship, the
accused person, he is illiterate, but he is resident at in Meghalaya. Does not. Lordship.
Transporting or possessing or whatever.
Lordship, may I submit it? Lordship, may I submit it on judgment Supreme Court Honorable? Lordship, kindly one.
কিচ্ছু শুনতে হবে না, এমনি রিজেক্ট হচ্ছে। চিন্তা করিস কেন? রিপোর্ট এসছে ওইখানে রেজিস্টারে।
Item number 15.
উঠে দাঁড়াও, উঠে দাঁড়াও, উঠে দাঁড়াও। কি হলো এটা?
None of yet.
কি হলো এটা?
Dismissed for default. দিয়েছি তো
কি বললো, কি বললো?
Dismissed for default, not bad.
Not placed হচ্ছে, not placed।
16 Milord IAP on behalf of the petitioner. Lord, firstly, I would like to submit, Lord, the petitioner before your lordship, Milord, is a lady who got married to a wrong person and is presently suffering incarceration under the NDPS Act. Milord, kindly allows me, Milord, kindly, Milord. Lord, the allegedly, Milord, commercial quantity of contraband was recovered from the house of the petitioner. Milord, the house doesn't belong to me. The house belongs to my father-in-law. Milord, kindly. Matrimonial house. My husband eloped from the place of occurrence, and subsequently he was granted bail by an order of the coordinate bench that there was no recovery from his possession. Now, my lord, my case is, if my lord kindly takes up the written complaint for once. 16A, my lord, page 16A of the FIR. It is a typed copy, but as because the FIR copy was not legible, I have annexed a typed copy. My lord, it says, may I read it, my lord? My lord, the complaints, page 16A. But the complaint starts from second paragraph, ISI Jagat Roy. ISI Jagat Roy, OC Jateshwar, outpost under Falakata PS, District Alipurduar, do hereby lodge this complaint to the effect that on 22/9/25, at about 17:45 hours, received an information. But kindly takes note of this, that he receives an information at 17:45. Now that kindly comes to the memo of arrest, which is as page 18. Column number 8, date and time of arrest on 22/9/25 at 10:45. It shows they received an information at 17:45 and she was arrested prior 5 hours prior to receiving the information. Now the arrest is itself in doubt. And that is my first argument. And my lord, they have the same finding in the charge sheet as well, that they received the information at 17:45 hours and they arrest the petitioner 5 hours prior to that. But I ask this question to myself as to how is this possible? Now, my lord, I primarily place my arguments on 2 points, my lord. My lord, the 250 gram is the commercial quantity, my lord. But I do not capsule. 250 gram of tramadol, my lord, falls under the category of commercial quantity.
14,400 piece of capsules.
So the weight is not specified. No, the weight is not specified. That may be part of the FSL report. My lord, I don't.
19,000 capsules.
Capsules, my lord. No, the weight will my lord, differentiate. My lord. No, the weight will be the differentiating factor. 250 gram is the my lord, commercial. 250 gram is intermediate. 251 gram will be the commercial quantity. Now, my lord, my argument is primarily on the point that, my lord, when the arrest is itself in doubt, as well as, my lord, the grounds of arrest, which is my constitutional right, but that was not informed to me by the police personnel, as per the dictum laid by the Supreme Court, as well as, my lord, by the Constitution of India. If my lord kindly, for one instance, my lord kindly takes up the Constitution of India.
Lordship. Time of arrest. There is an overwriting, Lordship. There is an overwriting, so I have to take instructions.
No, there's the same finding in the
Because-
charge sheet as well.
Because the arrest memo, I have to call the IO because there are anomalies. The arrest memo, all in carbon but written in. Yes, sir. I have to call the IO.
But my lord kindly sees the charge sheet as well. My lord, that is typed. How
Have to
that
call
cannot
the
be an
IO.
overwriting. The charge sheet is typed. That cannot be an overwriting. This. No, 22nd of September.
Would not have been prior to receiving this information. It has also been argued that the ground of arrest is not been intimated to the and the relevant arrest has been placed. Because the entire arrest memo is a private copy of it is only the time of arrest which is it's time to work further construction of the bank.
I know. Calculate.
Congratulations.
Item number 17.
Your Lordship, in this matter, we need to file one supplementary affidavit, Lordship, because in the application there is only FIR and the last rejection. There is no other documents, Lordship. Lordship, kindly grant opportunity to file a supplementary affidavit, Lordship.
How soon can you do that?
We will try to get as soon as possible, Lordship. As soon as the certified copy is available from the district court. Lordship, then kindly let me to seek instruction.
In item number 18.
কি হলো? সতেরোটা টুমোরো কি হলো? 18টা কি হলো? 18টা কি হলো? Not pressed. Not pressed. আঠারোতে not pressed. নাম দিচ্ছেন? 18টা কে ছিল? আরে দ্বিতীয় নাম দেখে দিতে হতো, ওকে জিজ্ঞেস করো না। আঠারোতে কি আছে? 18তে
একদিন accommodation. But I pray for a day's accommodation.
20তে কি হলো? 20তে 19টা কি হলো? কি নট টুডে হলো? 19টা কি হলো? 19টা নেক্সট উইক 21 না?
21.
Lordship, I am on behalf of the petitioner. Lordship, petitioner seeks this application before the Honorable High Court for the first time. Lordship, in this application for bail, the key ground is that there has been a delay of more than 1,098 days, Your Lordship, which is to say 3 years and 2 days. Petitioner has been in custody since 29th June 2023, Your Lordship. And since 14th July 2025, Your Lordship, the witnesses have failed to appear before the trial court for examination. Lordship, a total of 17 dates have gone by, wherein which the witnesses have failed to appear before the trial court. Lordship, the latest date was 18th June 2026. Lordship, on that day also, they have failed to appear before the learned trial court. Lordship, it's 1,287 loose SAM PFX capsules weighing 741 grams.
পিটিশনের কপিটা দেখি, পিটিশনের কপিটা। Lordship, I have seen it. The only issue is with regards to CSW 11 and 13. So what they are referring to, yes, there is a delay. So, but it can be sorted out. And if the investigating officer is called on next day, so any date on the adjourned date, I don't know because sometimes there is that PO is on leave sometimes. Yes. It's yes. Sometimes. So the issue is that sometimes PO is on leave, sometimes 11 comes, the 13 doesn't come.
No, Your Lordship, 11 and 13 have not consistently not appeared before the trial court. And
Sometimes
this delay
sometimes
has been
11
going on
was
for a
there.
year, Your Lordship.
I'm showing. 11 was there.
This delay has been going on for a year.
Hmm. হ্যাঁ 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 কি আছে এটা মধ্যে বলতো ইয়েটা তো বইটা তো কি আছে বের করো এটা প্রক্সি স্যাম স্যাম এফএক্স ক্যাপসুল এটা দেখো এই রিপোর্টটা সিএফএসএল সিএফএসএল এটা দেখতে হবে বাবু সিএফএসএল টা
Lordship, I'll just find.
ট্রামাডল কত ছিল কি কত জেড ছিল জেড ট্রামাডল ট্রামাডল কত জেড ছিল দেখ না জেড জেড না কি ছিল হ্যাঁ ট্রামাডল
Lordship, the next date is on 17th July 2026.
250 grams 250 grams recovered seven 741.77 grams.
Lordship, kindly consider there has been significant delay in the matter, Lordship.
Yes.
Lordship, and it's been over a year since witnesses have failed to appear, Lordship.
You said.
771. Sorry, 741. 41.77. Sam FX caps.
Same PS.
Yes.
Lordship, petitioner is the husband, Your Lordship. Yes, Your Lordship.
দুজনই তো করেছে দেখো তো বের করো
Lordship, the wife is already on bail.
Tramadol HCl. আমাকে এটা দে পিটিশনটা দে Even 13,
Your Lordship.
The deciding officer was not able to make any occasions. Has been brought to the next stage. Please look at the other side, what is correcting the child of the
as it appears that due to committee of competent athletes, where the election people is not inclined to allow the fair. The prior proceeds the time bound limits. The evidence of the CSW 11 and 12
11, 13.
shall be recorded as early as possible.
Lordship, one small point I would like to highlight before Lordship. Lordship, at the time of the search and seizure, Lordship, no female officer was present. There was only a female constable present during the time of search and seizure, Lordship, of the wife. Grateful.
Lordship, I'm praying for next week. Yes, Lordship, Monday.
Now rejected, it rejected.
Lordship, kindly keep it on Monday for my satisfaction. Monday. Next week, Monday. Lordship, I'm not actually. Yes, my lord, I can understand. Lordship. Kindly keep it next week. I'll do it next week, Lordship, Monday.
Joy. Very good. এটা যিনি কোনটা ছিল মুমতাজ সুলতান 23 বুকসো প্রেগন্যান্ট হয়ে গেছে বলো কি হলো বলোটা কি হলো
Lordship, I'm for the petitioner. Offences under section 363, 376, 506 of IPC and read with section 6 of protection of children from sexual offences. Lordship, I'm in custody since 9 months. Oh, I'm sorry.
Item number 5. Item number 7. Item number 23.
I'm for the petitioner, Lordship.
Ladyship, I apologize for that. Ladyship, I actually needed help. I needed help for that. Ladyship, I needed help to read that, Your Ladyship. So I was. Page 46 is also there, Ladyship, if it might help. Plain and clear. 43 and 46 is also there. Deceased. He's the eyewitness. Eyewitness.
That we can understand.
Yes, Your Ladyship.
In the written complaint, nothing.
As far as the statement and the role is concerned, he actually held the deceased and the accused, and the stabbing was done. So it happened, all three of them, they assaulted the deceased, and then the stabbing was done by them. That is specifically written. That I can concur, Your Ladyship. The FIR itself. FIR itself says that the stabbing was done by the prime accused.
Till 9.
Portion, Your Ladyship. FIR, if
নিবেদন এই যে আমি গত 7/3/2026 আমরা 9:00টার সময় নিয়মিত 1 নং আসামির নেতৃত্বে 2-3 নং আসামি এসে Yes, my lord. Kindly see the role ascribed by the present accused person, my lord. My lord, I have not accepted only the accused, my lord. I say the only instigation. But I say the only instigation, abatement, this at the time of, my lord, only Only presence, only instigation, my lord. Kindly see other involvement, my lord.
However, Your Ladyship, he is named in the FIR. He is named in the FIR as accused number 2.
Sunil Borman, charge sheet submitted as per under custodial detention, not necessary, my lord. If it is principal accused, not annex, not yet, not sir. I as per instruction, charge sheet submitted. Your lordship had.
Charge sheet is there, Your Lordship.
Submitted.
Charge sheet is there.
Your lordship directed, then I apply and.
I have, yes, Your Ladyship.
Not principal accused.
5/3/2026, Your Ladyship.
Basically, earlier it will be 326 and 302. 302 is now 103 and I will probably do the track. More than 110.
He was arrested on 5/3/2026. 2020. FIR.
$188.
Item 34.
Item 34, 35, Your Ladyship, I'm seeking short passover. Learned ABP is in his legs for code 5. Wait.
36 था तो 36
We are seeking password now.
36 we are ready with this.
35.
No, no.
I don't know 36.
And I am for the
Yes.
and I am for the in this case, from the possession of the petitioner, fake currency was recovered. The petitioner is custody more than since December. Petitioner is custody till today charge not framed, and there is no progress in trial. One thing, another thing, if your lordship kindly see the ground of arrest, not hardly communicated. These are my twofold submission.
Ground of arrest.
It is there, Your Lordship. It is there.
And what is the stage of the proceeding now?
That I have to take instructions because it is not available in the CD from the IO. But regarding investigation,
Investigation is continuing.
yes,
No,
sir.
not completed.
It is completed, but I would like to apprise Your Lordship that there is a report submitted by from Bharatiya Reserve Bank Note Mudra Limited, which affirms that the counterfeit notes are actually counterfeit of low quality. 499 pieces of 500 denomination notes have been seized from the accused in a local train, Your Lordship, in a general compartment.
Charge sheet submitted on 21st February 2026, madam.
पासवर्ड कर दीजिए तुम्हें बोल लेना
You're a government employee.
No, madam.
What do you do?
Not so like this, madam. There's no other.
What do you do? There is every chance that you will be convicted because the report from the Bharatiya Reserve Bank is
Madam.
it was recovered from your possession,
Madam.
right? So
May I one thing, madam. if your lordship puts Indian condition, I will remain in the trial court jurisdiction, my lord. It's not that, my lord. My lord, I have to take specific one adjournment, my lord. In this brief, I shot not today because, my lord, I have not properly gone through this brief also. If your lordship given 1 day second, then I have to take proper instruction from my client, my lord. If your lordship.
Tomorrow.
Not tomorrow. And diploma.
Learned APK has come. Possible.
37 item number 37. 37, my lord, I'm for the petitioner, my lord. I have tried to serve the victim, my lord. However, my lord, the tracking report, latest tracking report shows that, my lord, the addressee has left the resident, my lord. My lord, if it can be done through, my lord, the investigating officer of the relevant police station. My lord, I am only carrying the forwarding filter, my lord. My lord, that is the, my lord, the postal receipt is there, my lord. But inadvertently, my lord, the tracking report is not there, my lord.
It has been submitted by the learned advocate for the petitioner. The party was of these, as like the address where she stayed. Where has been direct service to the application. Service upon the private party.
Item number. ঠিক আছে item number 38 39
39 I'm pleading on behalf of the petitioner, Your Lordship.
My lord, it is not available. It is not available.
Your Lordship, in this matter, what is exactly, if I could make a short submission, Your Lordship. In this matter pertains to the year 2012, Your Lordship. The trial has already started. The petitioner failed to appear in the trial. Warrant was issued and subsequently he was taken into the custody. He is languishing in the custody for 2 months, Your Lordship.
Months?
Yes, Your Lordship. Earlier, he was granted with a bail, Your Lordship. He is not the principal accused, and that I can, Your Lordship can message page number 16 of my petition, Your Lordship. That is the evidence in chief of the de facto complainant, where she has specifically stated that due to stabbing, that is the third line, Your Lordship, due to stabbing by Buddhadev Hajra, the internal parts, Bhuri, came out. After happening the incident, I came to Alipurduar court probably, and written complaint was written as per my instruction. Thereafter, it was read over and explained to me, and having been satisfied, I put my signature on it. Written complaint is shown to the witness. The witness identifies her signature. So the present petitioner before Your Lordship is not even the principal accused. He was an accomplice of the situation, Your Lordship. From the
Where is the copy of the FIR?
FIR is at page 8 of my petition, Your Lordship. He is FIR named accused, Your Lordship. Two persons are FIR named, but he is the accomplice in that, Your Lordship, from the. Yes, he is FIR named, Your Lordship. He is FIR named, Your Lordship.
What is the stage? Trial has gone through, that sheet has been submitted.
Yes, Your Lordship, trial has started, Your Lordship. I have annexed the deposition of.
What is the status of the trial?
It is, there are several witnesses to be examined, Your Lordship.
Let him take instruction.
Lordship. 5 has been examined till date, Your Lordship, if I'm not wrong, out of 9.
Yes, my lord, there is serious allegation in FIR.
Please check up. Yes, check up and come ready on the day.
My lord.
Next Wednesday.
Grateful, Your Lordship. Grateful, Your Lordship. As per the certified copy, Your Lordship, out of 9, 5 witnesses have been examined. As per my instruction, Your Lordship.
I don't know. 40.
Grateful, Your Lordship. Grateful, Your Lordship.
I don't know. 40.
May I make one indulgence regarding item number 38? My lord, I missed it. My lord. Can it be?
Just come like it's faster.
41.
Matter of cancellation of bail.
I am appealing on behalf of the OP number 2. Kindly allow me on virtual mode.
My lord, so for the case is concerned, my lord, kindly see the page number, my lord, 13 and 14. That is the FIR lost by Misal.
And for the OP number 2, my lord, kindly grant me the leave to file a Wakalatnama as the learned put below.
Yes, I am appearing on behalf of the OP number 2.
Imposed some ground.
No, that is not a ground. Kindly see the order. I have seen the order. You have been directed not to appear, enter into the jurisdiction until and unless you have been directed to appear before the court. That is not a ground that you cannot execute Wakalatnama. Now, my lord, kindly see. My lord, now, my lord, so for the case is concerned, the case was initiated under section 6 of POCSO. The girl was
Many reasons, my lord. So, under such circumstances, my lord, standing on the same footing, my lord, there cannot be separate treatment for the persons, my lord, who are similarly circumstanced. 3 persons, my lord, all they were traveling together, they were apprehended together from the same car, allegedly. My lord, alleged recovery was made from them, all of them. So, my lord, if 2 of them have been granted bail on take, quantity is, my lord, 29.36 kgs of gaja. The commercial quantity is, my lord, above 20 kgs. My lord, coordinate benches have, my lord, even without going into the merits, my lord, up to 27 kgs of gaja, my lord, have been enlarged on bail. My lord, I am not on that. Yes. But, my lord, if there is a parity, my lord, I cannot be differentially treated, my lord, when 2 other persons on the same footing has been released on bail.
Difference in role.
Leadership, as far as Nirmal is concerned.
No, Nirmal is anticipatory bail.
Nirmal
His name was transferred from their statements in custody.
Yes, he was granted bail because his name was not in the FIR. Now, Sujan Borman, he was in the car along with the accused over here, the petitioner over here. And Your Ladyship, the petitioner, there is a possession of the petitioner. Yes, Your Ladyship. Now, I have the original CD. Yes. Seizure list is in page 9, Your Ladyship. At page 9.
From all of them's position, joint position.
As far as the
Everybody comes out, the racket starts flourishing all over again.
co-accused is
No. But if Lordship will take this view, then no, your Lordship should be strict, so far as NDPS matters are concerned. But when I am on a technical ground, I am on parity. So has to say that I do not stand on the same footing. That the recovery was only from me and not from the other co-accused persons.
And 180 statement is also there, Your Ladyship. If it is in page 37. And confession statement is also there, page 78 of the accused hearing. And confession statement is in page 78.
All day's job, that is how these investigations are carried out.
What is the position of trial?
Ladyship, I need to verify it, Your Ladyship.
What can you must be doing?
So far my instruction is concerned, I believe no witness has been examined as of date, but I have to take instructions on that way. Because my instructions is 3 months old. I do not know, what transpired in the last 3 months.
January 2025 incident. How much it has progressed?
I don't think,
Status of
two of the co-accused.
Obliged.
Item number 7. Item number 7.
Lordship, I am on behalf of the state, Lordship.
Dismissed.
Item number 7 for not this. Item number 7, Lordship.
Adjourned on the last occasion, why is it urgent today?
Lordship needs some instruction, Lordship.
Instruction. Whatever is there on record.
Lordship, then I'm only praying for not today, Lordship.
Urgent for the day on the fair of the learned education.
Item number?
24, I'm ready not to compare your leadership.
I am for the state.
Yes, it was passed over on the first occasion, Your Leadership. May I submit my case, Your Leadership? Your Leadership, the victim is a
POR, that is prosecution offense report, that is treated as charge sheet, has already been submitted in this case. Allegedly, 580 grams of pangolin skin has been recovered from my possession, my lord. Kindly see, my lord, page 12 and 13. 12 is the arrest memo of the application, my lord. Kindly see. 12 of the application. The arrest memo. Kindly see the column number 8. Signature of the witnesses. First one is Amor Roy, FG, that is forest guard. Next one, my lord, some Modak, BS, that is my lord, Bono Shevok. My lord, all the, and the in the arrest memo also, seizure list also, my lord. The independent witnesses are not there in the seizure list and the my lord, arrest memo. My lord, the NH, National Highway, my lord, NH 31, time, kindly see my lord, time 5:10 p.m. There is no reflection whether they approaches the independent witnesses and they have not turned up. And regarding that, no FIR has been lodged before the nearest police station by the inquiry department. There is no reflection. But the alleged recovery has already been made. My lord, I am handing up one coordinated bench judgment, my lord. Kindly see. Fortunately, my lord, I am also appear for the petitioner in that case also. That was the 101 days custody of the petitioner. Here is my lord, 188 days. Trial by the magistrate. Maximum punishment is 7 years. Minimum 3 years. My lord knows the DK Basu's judgment. Pencil. Yes, my lord. Pencil. POR submitted, my lord. POR, for prosecution offense report in the wildlife or forest cases, there are investigation was done by the inquiry department, the forest department. That is called POR, prosecution offense report. That has been submitted. No independent witnesses in the seizure also and in the arrest memo also. I will face the trial, my lord. The department, all the witnesses are departmental, so my lord, there is no chance of any tempering of the evidences. My lord, the elephant tusk. No. That was.
Oh, this one angle elephant.
Here is pangolin skin. That was the elephant tusk. Yes, my lord, as because the elephant tusk, value of the elephant tusk is more high, my lord. That is why, my lord. My lord, my lord. I'm admitting this. That is my lord. But jackets or shoes, belts.
Not in India.
Yes, what is your submission?
Lordship, we are opposing the bail prayer, and the submission made by my learned friend that there was no witness, and we have not mentioned where it is there, Lordship. That during the seizure process, some passers-by gathered thereby, but despite my several requests, none of them were willing to be the witness to the seizure. Then on my request, on duty forest staff signed in the seizure list labels and memo of arrest as witness. It is their lordship. Regarding that, no case has been registered. With respect to the yes, with respect to that, we can try to expedite, and if 1 day or 2 days accommodation is given to us, we'll ascertain that how much time it will take and how much witnesses has been assigned. না সেইটা বক্তব্য না, বক্তব্য যদি
But only 4 witnesses are there, my lord. Only 4 witnesses in the POR, prosecution offensive, my lord. 5, maybe. In that case also, my lord, 5 witnesses are there.
The scientist will not turn up, another 4. এটা নিয়ে আসো, এদেরকে ডাকো, ফরেস্টের লোককে ডাকো, কালকে ডাকো, কোনটা এটা? 34 আজকে আর পারছি না।
My lord.
So it is there in BNS also, lordship. No, BNS also, lordship. Yes, there has to be like a time bound. It is there. I forgot the provision. 50 কত ছিল? 50 কত? দেখি BNS টা দে তো। BNSS.
POR.
তারা বলছে ইয়েকে ফোন কর, শোন, ইয়েকে ফোন কর। কত বলবে Eight. এগুলো একটু লেখো। কোথায় চলে গেল আমাদের সিএ স্টাফ? কি অবস্থা! স্ট্যাটাস অফ ট্রায়াল। $35. Lordship, next week, lordship. 35. Next week. এটা মনে হয় আরো অ্যাকিউজড আছে না?
I don't know, 38.
একটাই?
Paying for 1 day. No.
38. উফ, নেই, ছাড়ো না। আচ্ছা, আমার আসে না, সেটাই তো জিনিস। ছেলেরা আছে।
Tomorrow. Well, this is the matter where learned additional advocate general sir will be appearing, but he is not here, my lord. That's why they prayed for tomorrow, my lord. Kindly fixes it for on a time, my lord. My lord, why am I saying this, my lord? This matter has been running in the cause list since last circuit, my lord. 4 times in the last circuit. It could not have been. It could not have been heard by.
They are political persons. They cannot enter into the.
And my lord, your lordship will be astonished with the facts, my lord. The principal accused. My lord, I am very confident on that. Every day, my lord. I'm very confident about that. But
Is that we have no objection, but I do not want to praise that one. So,
as learned AG will be appearing, my lord, kindly fix this sometime. It will be convenient for the learned AG, sir, my lord. Oh, my lord. Then, but the problem is that 4 times it has been because he could not manage the time, my lord, with this one.
yeah, I will take instruction.
তাহলে তুমি করে দাও না এখন এখনই করে দাও তাহলে The principal accused was granted with anticipatory bail. My lord, my condition is that I will not enter into any political activity. I will not enter into my own hometown, my lord. This kind of. My lord, yes, my lord. The principal accused name is Bimal Guru, my lord. He is granted with an anticipatory bail.